G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law podcast. If you're on YouTube, please subscribe. We love our subscribers. Today, I'm talking about another drama in Queensland, and this is about who is a family. Queensland Health, for reasons best known to itself, has determined that for the purpose of family limits, with the use of donor sperm, that two women who are living together as a couple, they're married or not, are separate families. So just let that sink in for a sec. They're a couple, they might be married, or they might be in a de facto relationship, or even, as Queensland allows, a civil partnership, are considered by Queensland Health to be separate families. Queensland Health took the view in the lead up to the enactment of the Assisted Reproductive Technology Act 2024 in Queensland, that there should be 10 donor-related families, and these should be in Australia. And I was cheerful at that news because in a population of 28 million, we've got 8 systems of regulation of IVF and related matters. And therefore, we have family limits, and rightly so. We don't want children waking up to discover that they've got umpteen siblings. In 2 states, New South Wales and WA, and also the practice in Tasmania is 5 families. In Tasmania, you can understand why. In the rest of the country, it's been 10, and the ACT, because of its small size, has now said 5 within the ACT, 10 Australia-wide. So the general rule has been 10. I certainly advocated for 10 because if you leave it at 5, as New South Wales has now demonstrated, there isn't enough access. What we've seen from New South Wales is that since New South Wales Health last year said to all the clinics, no, our view of our legislation is 5 women refers to 5 women in New South Wales. The result has been that the cost of sperm available in New South Wales has shot through the roof from about $2,000 to $40,000 to $60,000 because overseas sperm banks, to make a buck, say, well, we could supply this sperm elsewhere, but because you are insistent on these numbers, it's only being supplied to you and you have to buy all the sperm. So a woman who wants to be allocated the sperm suddenly finds she's the owner of 20 vials when she only needs 1 or 2. The result is that those women who do not have the money for that extortionate cost have gone interstate, or they've gone overseas, or most worryingly have gone to unregulated private donors where there's no cap, or given up. And what are we doing in Queensland? Well, the same is happening in Queensland, that even though it says 10 donor-related families under Section 25 of the Assisted Reproductive Technology Act in Queensland, Queensland Health has interpreted that families, the 2 women living together, get sperm from one guy as being separate families. Now, you might think that doesn't pass the pub test, and I certainly don't, and I think it's certainly clearly discriminatory. But let's look at what the legislation says. Section 25(6) of the Assisted Reproductive Technology Act, the very section that talks about this family limit, says, for this section, a family comprises a parent, their spouse, if any, and their children. And who is a spouse? Well, Queensland law under the Acts Interpretation Act says it's you and your married spouse, in other words, under the Marriage Act, and we know since 2017 that lesbian couples have been able to marry, just like gay couples have been able to marry. And also, if you're in a de facto relationship or a civil partnership. So suddenly, even though you are recognised as a couple under Queensland law, and this act says that you are spouses, somehow Queensland Health has interpreted that as you're not. And just so we're also clear, the Family Law Act says that if you and your spouse or partner, de facto partner, engage in assisted reproductive treatment together, to use the jargon, an artificial conception procedure, and you both consent to it, you are both the parents. And if that weren't enough, the child is the child of your relationship. Family Law Act is crystal clear about that. In other words, both these people are the parents of their child. And under the Status of Children Act, if you have a female couple and they both consent to the fertility procedure, and this is Queensland legislation, they are both the parents. So despite this plethora of legislation that makes it quite plain that this woman is in a relationship with that woman and they are spouses and they are parents of their child or children, somehow Queensland Health has interpreted that as they're not. Now, I've certainly been approached by those who are affected by this, and I know that there are others who are affected by this who have been told, well, we're sorry, you miss out. So for those, if they're brave, they'll take on Queensland Health in an anti-discrimination claim or off to the Supreme Court. But few are so brave. Instead, they're more likely to have to go to Queensland Health and seek cap in hand, please, sir, may I have some more? Can I please have access to this sperm that we agreed as a couple to use? Now, I think where Queensland Health has got this wrong, aside from the plain reading of the legislation, is that this view reflects views taken by IVF clinics 5 or more years ago. Because it used to be under the previous regime of family limits, which is the National Health and Medical Research Council, ethical guidelines on the use of assisted reproductive technology in clinical practice and research, which is issued by the NHMRC, that there had to be reasonable family limits. And clinics used to say, well, each woman is a separate family and count the numbers accordingly. Well, 5 or so years ago, clinics wised up and said, well, actually, that's discriminatory to lesbian couples. We should be including each of them together as a family, not count each of them separately as a family. So the view taken by Queensland Health now does not reflect the practice of IVF clinics prior to the commencement of this provision. This is something that reflects what used to happen quite a while ago. I hope that this does not continue, and I hope that the Health Minister, Tim Nicholls, directs Queensland Health that it is plainly obvious that these women who are a couple together are in fact a couple, not separate families, and should be treated as one family, not two. That's my hope. Let's see what happens. Thank you for watching and listening. I'm Stephen Page from Page Provan Family Fertility Lawyers. This is the Australian Family and Fertility Law Podcast. If you're on YouTube, please subscribe. We love our subscribers. Thank you. Bye-bye.